So welcome to the Courts and Society webinar series 2003, the 5th edition, which is the first for this year. So our program, as we see, the Honorable Ambassador Tijani Mohammed Bande would be our distinguished guest of honor, and he would be giving his address shortly. The Honorable Justice James Ogebe, retired, would be giving the keynote, as we all see in the program. And our first discussant will be Malam Yusuf Ali, Senior Advocate of Nigeria. A second discussant will be Honorable Justice Adam Onum, retired Chief Judge of Benue State. And the third discussant would be Mrs. Nella Andem Ewa Rabana, Senior Advocate of Nigeria, who would also be giving a third discussion, a public policy expert. And then the fourth would be, and the last but not the least, Mr. Kunle Lawal, the Executive Director of Nigerian Electoral College. It is important at this point for me to please bring to all of our attention that this is a controversial and touchy topic, as we know. However, it is not partisan. This is not a partisan forum. We're not here to advertise or to campaign for any political party or position. This is an academic and judicial forum. So be civil and respectful with your questions and comments. Because of the nature of the topic, we have decided that all questions and comments will be directed to Ugo and to Liz, please, or me, to avoid any biased, offensive political remarks that may be put out there. Speakers are at liberty to refrain from answering your questions. The speakers were chosen before the elections, by the way, and you would know why I said this as we go on. There are no right or wrong views, comments, or answers. And this is not an attack on judges. We are just focusing on the way forward to help the judiciary in this time.
Recording in progress.
I quote the Honorable Justice Monica Dongban-Mensam, the President of the Nigerian Court of Appeal, and I also quoted the late Honorable Justice Nikki Toby, where he says that judges are not making extraordinary demands, supporting Justice Dongban-Mensam's comment. A brief history of the Court and Society webinar series. This CSWS originated from the Honorable Justice Nikki Toby first biennial symposium that held in person in Abuja, Nigeria, December 2nd, 2021. And that webinar had 4 sessions. The first session had to do with judicial society, the court's role in developing society. The second session had to do with judicial precedents. The third session had to do with legal education. And the fourth session had to do with human rights. And so after this symposium, we decided to break down each session of the symposium into webinars so we can discuss more and build judicial jurisprudence and help to develop and advance the system, judicial system all over the world. So the first Courts and Society webinar series was in April 2022, and it was titled The Impact of Judicial Precedents in Societal Development. The second one held in July, The Impact of Judicial Education on Developing Law and Society, and the last, for last year, was the court's role in human rights, in upholding human rights in a diversified world. I quote Honorable Justice Nikki Toby when he said that Nigerian judges must maintain a very big distance from politics and politicians. Our constitution forbids any mingling. As judges, we must obey the constitution. The two professions do not meet and will never meet at all in our democracy in the discharge of their functions. While politics as a profession is fully and totally based on partiality, most of the time, judgeship as a profession is fully and totally based on impartiality, the opposite of partiality. And so judges should, on no account, dance to the music played by politicians, because that will completely destroy their role as independent umpires in the judicial process. So what are our goals and objectives? The Courts and Society webinar series has general goals and objectives, but specifically, we tweaked that for this special edition, this special edition for the elections in Nigeria and other African countries. So we want to build public confidence in our court systems. We will agree with me that that is a major problem in many African countries with the courts and societies. We want to understand the value of courts in developing democracy. We want to discuss contemporary issues affecting judges, good governance, and the rule of law. We also want to foster intellectual, legal, judicial relationships across board from different countries and different judiciaries. We want to inspire further research, very key and important in courts and society. Students are in attendance, researchers would pick up topics and go on researching to build judicial jurisprudence, because we also know that we have, for those who are researchers, we see that there are many research institutions that would need more of African jurisprudence, and we need to inspire that in such forums as this. To advance judicial jurisprudence and ensure socio-judicial development, we want to propose solutions at the end for societal and democratic development. For those of us that are joining from other countries, other jurisdictions, a brief fact about Nigeria. Nigeria is known as the giant of Africa, one of the largest populations, and indeed the largest population and economy in Africa. Nigeria occupies a strategic spot in the global democratic agenda. Although she keeps struggling to retain this title, Nigeria's GDP in 2021 was about $441.5 billion US. But although it crashed in 2022, slightly. This illustrious yet highly battered land of green, World Bank reports, is an emerging economy. I probably perceive a lot of people saying, we have all this money, we made all this money, where did it go? Maybe an anaconda swallowed all the money. This Africa's corner piece holds a strategic position in Africa's future and other democracies like the United States. And I just thought of it that maybe, could this be why the US is building its largest embassy in the world in Lagos, Nigeria? Nigeria is a stakeholder in global democracy. Nigeria has an estimated population of 213.4 million, I think we're more than that, and over 250 ethnic groups that speak about 500 different languages, and no, we do not understand one another. At this point, even though Nigeria is our focus, the challenges that Nigeria face in the electoral process cuts across African countries and developed countries as well. For those who think that it's just because the spotlight is on us, we are the only ones that have problems. Even developing countries like America have those issues as well. So we salute the other 23 African countries that are electing leaders this year, 2023. Including Nigeria, there will be 24 African countries this year. So some of you attendees responded to our questions about what your expectations would be for this webinar. How the courts, rather than the people, vote in gradually deciding our elected leaders in Nigeria, and how this trend can be reversed. Somebody said, I study election law, courts, election and administration in the US and Europe, and I don't know nearly enough about the same in Africa. I'm happy to learn more. And on. To save time, I will just skip all the others. At this point, before we give the floor to the ambassador, it is our culture to honor any dignitary that appears before us with a national anthem. So since we cannot stand, or I would not consider us to stand, want us to stand, I beg your pardon, not to offend anybody or any protocols, we will not be singing the national anthem, but I would be reciting it. Arise, O compatriots, Nigeria's call obey. To serve our fatherland with love and strength and faith. The labor of our heroes past shall never be in vain. To serve with heart and might, one nation bound in freedom, peace, and unity. The Honorable Ambassador Professor Mohammed Bande is a Nigerian diplomat and political scientist. He started his academic career as a graduate assistant at Usmanu Danfodio University, Sokoto, Nigeria. Eventually, he became the Vice Chancellor, and in his tenure as VC, The university ranked first in the accreditation of academic programs in Nigerian universities. His Excellency was the Director General of the National Institute for Policy and Strategic Studies, Nigeria's most reputable policy institution for training leaders from the public and private sectors. Most notable of his initiatives was the establishment of the Political Parties Policy and Leadership Development Center in Nigeria, which is the first of its kind in Africa. Ambassador Bandi's ministerial service to the Federal Republic of Nigeria attracted several awards and honors, including one from the government of the United States of America, excuse me, and another from the Chinese government. Most notably, he was conferred with the prestigious Order of the Federal Republic and Nigeria's highest national honor for Grand Commander of the Niger. Ladies and gentlemen, I would give the floor to His Excellency, the Honorable Ambassador Tijani Muhammad Bandi.
Thank you very much, Madam Moderator, and please allow me to stand on existing protocol and to also acknowledge that certainly this is quite an interesting conversation. The series Courts on Society is really important in the context of our effort to deepen democracy in Nigeria and also to advance scholarship, because these things must go together. And the subject itself concerning the role of the court in Nigeria's electoral process is a permanently critical one. The setting has been set by the moderator in terms of the importance of the courts, not only in society, but in this particular case, in relation to the electoral process. If we get our elections right, we're likely to get a lot of things in our governance right. And in particular, because of passions that are associated in all countries with elections in terms of leadership transitions, it is certainly important that we continue to sharpen not only the electoral process in terms of the act, but in particular in terms of what the courts can do. And this is critical. The whole question of the impartiality of the courts is there. The whole question for me of sending a message properly that Nigeria is part of a family of democratic nations, and its traditions are different, but it's still within a larger tradition of democratic societies, and the courts have a critical role in adjudication of disputes as arise in society more broadly, but in particular in terms of the contest for positions through the electoral system. And therefore, the issue of impartiality must be critical. The issue of justice in terms of fairness, of course, must be critical. The issue also of wisdom, where situations become extremely difficult to fathom, certainly the system requires a bit also of wisdom, especially where there can be conflicts in certain settings. We find it easier, of course, in Nigeria, given that we have several levels, like most countries. You go to court, a determination is done. If you are unsatisfied, there are other courts. And obviously, we must accord full respect to the courts. And in particular, there needs to be a way in which decisions of courts, especially in electoral matters, are not left to simply speculation as to basis upon which judgments are made. And that's one element I want to urge, is that let us have a way in which those knowledgeable in the law can guide reporters as to the issues. Reporters with a background in judicial studies or in terms of the law in particular need to be involved in the way the media also engages the courts. And this is one element, so that speculation and innuendos are removed. Certain judicial pronouncements have looks a bit strange for lay people like me. In the country, there are many such cases in relation to the courts. It doesn't mean they are wrong. It only means it's important to communicate the jurisprudential basis upon which certain decisions are made, or the basis upon which what arguments are made in court. This is important because we do like the fact that more and more those who have lost in the elections realize that no longer is it acceptable for you to simply try cases on the streets. You go to court, go to the next court, and when it gets to the Supreme Court, we must respect the pronouncement of those courts. And we have to have laws really targeting those who, in spite of judicial pronouncements, begin to disparage the system so that we deepen our democracy. I say this in particular as a Nigerian and a senior Nigerian at that, but also in my current role, I know the battle we have to fight to appreciate that a lot of people do not understand our system. And they have difficulty principally because of the kinds of things they read in the press. I think Nigeria is connected very heavily to the world. And a lot of people, for perhaps a variety of reasons, are interested in what happens in Nigeria. Not only do we have, we are a country that has, certainly in the United States, a number of Nigerians who are doing extremely well, who either have dual citizenship or engaged in some activity here. And they also are a contributor to what Nigeria can become. They also need to appreciate what is there. So communication as to the basis of the judgments would help from those who are knowledgeable, rather than leave space for all kinds of people who are making simple statements based on nothing other than sentiment. I think this is important because Nigeria continues to play an important role, not only in the sub-region West Africa and Africa, but in the world at large. Personally, for me, this kind of engagement is important. I've had judicial officers, either retired or serving. I've had names of scholars and practitioners. I think this is a very important engagement, and the results of such need to be also made more widely known. I am glad that I have an opportunity to listen to knowledgeable people about this very, very topical and permanently important subject for Nigeria and for the health and progress and peace of Nigeria. This is what is really important. Nigeria is a very important country in the world. We must continue to uphold the rule of law, to support the work that judges do, and for the judges to also realize that a lot actually is placed on their shoulders as final arbiters when disputes arise, whether in the realm of elections or elsewhere. I thank you, ladies and gentlemen, for giving me the opportunity to learn. I will beg your indulgence that I will have to leave for another assignment by 9:45. So I will learn as much as I can before I leave. I thank you greatly for inviting me to participate in this important process. Thank you very much indeed.
Thank you so much, Your Excellency. We appreciate your comments, very insightful about the press and about the judiciary having somebody that would be able to educate people about such issues. And that is the essence of the Courts and Society webinar series. The Honorable Justice James Ogebe, OFRCON, retired Justice of the Supreme Court of Nigeria, Daily Trust published this about him, I quote, "Ogebe's courage and unflinching commitment to the rule of law and the Constitution saved our democracy from continued victimization," end of quote. That is 29th of March, 2020. His Lordship's judgments in the high-profile Ladoja and Obi cases established impactful precedents in Nigeria's socio-political history which subsequently influenced Governor Doreye's case as well. In both cases, both Ladoja and Obi cases, his lordship headed the panel that presided, the legislators defiled unambiguous constitutional provisions. So his lordship's unflinching consistency and adherence to constitutionalism in both cases has stifled threats to impeachments, at least to a large extent. Honorable Justice James Ogenye-Ogebe started his judicial career in the Magistrate Court of Benue State, where he ascended to the High Court and then to the Court of Appeal. He retired as Justice of the Supreme Court of Nigeria on March 22, 2010. His book, Justice Under the Shadow of the Almighty, details his judicial journey of challenges that reveals the Nigerian judiciary's behind-the-scenes struggles. That is a must-read book. My Lord served as chairman of several commissions of inquiry and the state's Robbery and Firearms Tribunal. He was awarded the Distinguished National Award of OFR and CON, Order of the Federal Republic and Commander of the Niger. The Golden State University, California, USA, and the Benue State University, Nigeria, each awarded him an honorary doctorate, Doctor of the Law degree, LLD. Justice Ogebe's post-retirement life is devoted to humanitarian services, ministering the gospel of Jesus in rural areas, mentoring justices, and discussing his revelational book. Our next speaker, Malam Yusuf Olaolu Ali, Senior Advocate of Nigeria, is the principal and founder of Yusuf O. Ali and Co. Galeb Chambers, with head office at Ilorin and branches in Lagos and Abuja, Nigeria. He served as the chairman and editor-in-chief of the Nigerian Bar Association. He is certified a notary public in Nigeria. He was conferred with the prestigious Senior Advocate of Nigeria title in 1997. He is a life member of the Body of Benchers, a life bencher. He's a frequent expert guest on diverse reputable media platforms. And I guess when the Honorable Ambassador said something about media, I know that just Malam Ali SAN is one of those that would be enlightening, that has been enlightening the public on electoral processes. And he gives his unique empathic perspectives on discussions around rule of law, good governance, corruption, and the electoral process. Malam Ali, Senior Advocate of Nigeria, also served and is serving on the boards of many companies, institutions, and organizations. His expert in election law enabled his appointment as the sole judge of the Kwara State Local Government Election Petition Tribunal. The learned Silk has delivered several papers on diverse subjects and topics at various fora within and outside Nigeria. He has published many peer-reviewed articles within and outside Nigeria and contributed several book chapters. He authored The Anatomy of Corruption in Nigeria, Issues, Challenges, and Solutions. His commitment to social change extends the legal practice to philanthropy as the founder and chairman of the Yusuf Ali Foundation, devoted to changing lives in Ilorin, Kwara State. The Honorable Justice Adam Ocheme Onum, retired Chief Judge of Lagos State. Well, I beg your pardon. I'm missing the state I served, the judiciary. Was a judge of the High Court of Benue State. He ascended to be Chief Judge and Head Judge of the Judiciary of Benue State before his retirement. His judicial career started in Bandikia, Benue State as a magistrate. My Lord was the Solicitor General and Director General of Benue State Ministry of Justice and Attorney General and Commissioner for Justice. His Lordship served on several committees on the amendment of the Nigerian Constitution. He served in several election tribunals across Nigeria, Delta State Governorship and Legislative Houses Election Tribunal, tribunals in Zamfara State, tribunals in Benue State, tribunals in Akwa Ibom. As a result of his commitment and dedication to election cases, my Lord received several awards from the Performance Evaluation Committee of Judicial Officers of Superior Courts of Record in different regions in Nigeria. My Lord keeps busy post-retirement as a member of many community boards to help community development and with his judicial expertise. He has authored 2 books with several articles. Mrs. Nella Andem Ewa Rabana, Senior Advocate of Nigeria, is a principal partner of Lex Global Partners, a renowned legal practice and consultancy firm based in Calabar and Abuja, Nigeria. She's the executive chairman of Sonergy Resources Limited, an oil and gas related business. She is the chairperson of the advisory board of the Electoral College. Mrs. Rabana was a deputy gubernatorial candidate in Cross River State. She was also Cross River State's former attorney general who joined Nigeria's legal team that represented Nigeria at the International Court of Justice regarding the Bakassi Peninsula Association to Cameroon in 2006. Thus, she became the first African female to address the ICJ as counsel. The Gender Perspectives 2002 edition listed Mrs. Rabana SAN among the top women leaders in Nigeria. She serves on the board of several private companies and is a regular speaker on several local and international platforms where she addresses issues on legal reforms and advocates for positive social change. The Leonard Silk, has been a public policy expert for over a decade. She was awarded the prestigious rank of Senior Advocate of Nigeria in 2009. She's a life bencher, Nigeria's body of benchers. Last but not the least is Mr. Kunle Lawal. He is an innovative entrepreneur, politician, and patriot. He's a public speaker in various forums, including TEDx talks. He is executive director of the Electoral College in Nigeria. After several years of campaigning on the importance of an electoral college in Nigeria, eventually he is heading that as an executive director. Mr. Lawal is also the managing partner of Sands Law Limited. He was a senatorial candidate in the Federal Capital Territory, Abuja. He consulted for the American Society of Microbiology. Mr. Lawal was also a personal assistant to the Honorable Minister of Women Affairs on IT and Publicity. He was once acting National Publicity Secretary of the COA Party, FCT, Abuja, and Alliance for New Nigeria Senatorial Candidate 2019. And he has since transitioned to a non-partisan influential player, in politics and electoral matters in Nigeria. Mr. Lawal is a multi-ethnic Nigerian who is focused on changing the Nigerian narrative in political participation and has gathered diverse political experiences working with non-governmental organizations and the federal government. His passion for Nigeria has led to his authoring the book, The Candidate, canned by the political landscape in Nigeria. So, ladies and gentlemen, my Lord Justice Ogebe.
All protocols observed. I'm privileged to give this keynote address in this webinar. I retired from the Supreme Court of Nigeria in the year 2010 and decided to put the law behind me and pursue other interests. However, on the pressure of Dr. Ari Nikitobi to tap my experience on election matters, I was obliged to participate. In any democracy, which is defined as the government of the people, for the people, and for the people, election is cardinal. Where there are elections, there will be winners and losers. Where there are winners and losers, there will be most often aggrieved persons dissatisfied with the process or the outcome of the election. Where there are aggrieved persons, there will be cause of law to adjudicate over the disputes. Therein lies the role of the courts in the electoral process. The disputes that involve the court could be compartmentalized broadly into disputes: one, over qualification of candidates; two, process of election; and three, the outcome. The legal framework for the court's involvement in electoral adjudication in Nigeria includes the Constitution of the Federal Republic of Nigeria, 1999, as amended, the Electoral Act, 2022, the Electoral Regulations and Guidelines, the Election Tribunal and Court Practice Directions, 2022, the various court civil procedure rules, other statutes, and the case law. General elections in Nigeria. In Nigeria, general elections are held every 4 years to elect leaders nationally and subnationally. For the national elections, the following political offices are contested for: the president and vice president a joint ticket, 209 senators of the Senate, 360 members of the House of Representatives. Subnationally, of the offices open for election are 36 state governors and their deputies on joint tickets and 36 state houses of assembly members. Now, pre-election disputes. By and large, candidates of the various political parties are selected by the parties and presented to the electorate for the elections. The selection process by the political parties is usually conducted in a process called primary elections, involving only card-carrying members of the political party. This is majorly where disputes arise as to the qualification of candidates to run for the office and whether all the processes for a just and fair primary election were observed by the political party. Accordingly, all disputes relating to disqualification, nomination, substitution, and sponsorship of candidates for an election preceding the voting proper in an election are treated as pre-election matters. The courts have generally taken a strict posture of declining to intervene in the internal affairs of political parties, as the parties have the right to manage and conduct their own affairs. However, the courts only intervene where the political party blatantly breaches its own constitution and guidelines and applicable electoral act. Herein is a brief analysis. Voter registration. The court has a role in ensuring that the voter registration process is fair and transparent. This may involve resolving disputes related to eligibility of voters or the challenges of the conduct of the registration exercise. Cases arising from this are rare, few, but the court can intervene when appropriate. Then the parties' primaries. The court has jurisdiction to determine disputes based on irregularities in primaries of political parties, and it plays this role by pronouncing on who is expected to vote or be voted for, the rules for the primaries, which are based on the constitution of the party, the guidelines given by the Independent National Electoral Commission or the party, and there is no outside interference. While reiterating that INEC, the Nigerian police and state security services only play the role of observers. Nomination of candidates. The court may be called upon to resolve disputes relating to eligibility of candidates or challenges to the nomination process. In this regard, it must be borne in mind that although it is the exclusive preserve of the political party to present a candidate for an election position, the court can always intervene where, for instance, a political party decides to wrongfully substitute the name of a party who lawfully won its primaries with a party who did not win the primaries. The campaign period. The court may be required to adjudicate on cases of hate speech, incitement of violence, or other violations of electoral laws during the campaign period. In post-election disputes. After the elections and declaration of results, candidates dissatisfied with the results approach election tribunals with petitions to seek redress. These post-election disputes, which take the form of election petitions, are concerned with occurrences on election or voting day, including collection and declaration of results. The court may intervene under any of the following areas. 1, election results. The court has always played a fundamental role in the aftermath of every major electoral process in Nigeria. The country gained her independence. in 1960. With the concomitant emergence of democratic practice in the country, the court has always been involved in resolving disputes relating to the announcement of election results, including cases of where there are allegations of vote rigging, fraud, and other electoral malpractice and irregularities. Under the Excellent Electoral Act, this process is usually commenced by filing of a petition by the party dissatisfied with the outcome of the elections. The voting proper. The court may be involved in ensuring that the votes process is free, fair, and credible. This may include resolving disputes related to accreditation, voter intimidation, voter buying, or other electoral malpractices. The law is right that a voter is disenfranchised when his right to vote is taken away from him. That is to say, a person who is a registered voter but was not allowed to vote. Vote counting. The court may be called upon to resolve disputes relating to the counting of votes, such as allegations of vote inflation or irregularities in the vote counting process. The court has variously played this role by pronouncing on what a valid or a lawful vote is. It has also given verdicts on sorting and counting ballots. Closing overview. At the first instance level, the tribunals are comprised of 3 High Court judges, with the most senior of them presiding. The election petitions must comply with the stipulation of the Electoral Act and guidelines provided by INEC. The grounds for the petition and the relief sought must be, by the petitioner must be clearly stated. Several cases are lost when the right parties are not there for the petition. The grounds for the petition, the relief sought, the petitioner must be clearly stated. The parties to the petition must be clearly stated. The lawyers for the parties present their evidence and their submission before the tribunal. The tribunal judges must examine complaints of the petitioner and the response of the respondents before reaching its decision. It is important that in election matters, the courts should not allow technicalities to throw out petition. They should ensure substantial justice. The essence of such adjudication to determine popular will of the electorate, as demonstrated from the evidence. It's unfortunate that some judges have imposed unpopular candidates in their judgments. This makes the judiciary subject to critical attack by the electorate. Proof required for successful election. Some of the grounds for challenging the results of the elections may be with respect to the qualification of candidates, non-compliance with the Electoral Act, and corrupt practice. Example of corrupt practices include bribery and forgery of certificates, which must be proved beyond reasonable doubt, as in criminal cases. Non-criminal grounds of petition are proved by preponderance of evidence on the balance of probabilities. Appeals from election tribunals to the Court of Appeal. Aggrieved parties from decisions of the Electoral Tribunal are at liberty to appeal to the Court of Appeal. This amendment is an abuse of process by politicians to give additional burden to the Supreme Court, which is usually overstretched even at the best of times outside the election years. Such appeals used to terminate in the Court of Appeal, and there was no serious reason why they should further appeal to the Supreme Court. The earlier petitions are disposed of, the earlier the governments that are coming in are able to settle for the job. So there's no reason why the appeals should go from the tribunal to the Court of Appeal and then out to the Supreme Court. I think the politicians or the government should look at it more carefully. I think the court for the governorship, it shouldn't go beyond the Supreme Court. The Supreme Court should do more serious cases, including that of the presidency. The Court of Appeal, comprising of 5 justices, constitute the Court of Appeal for first instance in respect of presidential election petitions. Aggrieved parties from the judgment of the Court of Appeal have the right to appeal to the Supreme Court before a panel of 7 justices. The Court of Appeal and the Supreme Court should consider carefully the issues raised by the appellants before their judgment. Under no circumstances should they raise issues suo motu. I wish to emphasize that the essence of an election appeal is to review the facts and the law in order to ascertain the true winner of popular votes in the election. There were instances in recent appeals in the Supreme Court of Nigeria, in particular, where the manufactured winners inconsistent with the facts, the case, and the Electoral Act. A notorious one was the case of Imo, where the contestant was number 4 in the election and had his case dismissed by the tribunal in the Court of Appeal, and surprisingly, the Supreme Court allowed them to bring some evidence of some votes which he claimed were not counted, and wrongly said he declared him the winner. It's a notorious case, and because of this, all judges who are involved in election matters will be upright, to follow the law, to not allow any kind of influence whatsoever, to fear God and do what is right, because election matters determine the governance of Nigeria or any nation for that matter, and it should be done with the most scrupulous attention to what is right and what is wrong. In conclusion, before concluding this write-up, I wish to consider an anomaly with regard to pre-election cases. While election appeals in respect of National Assembly elections, namely the Senate, the House of Reps, and election of members of the House of Assembly, terminate in the Court of Appeal, pre-election disputes regarding primary elections into aforementioned positions originating in the High Court can be appealed up to the Supreme Court. It is my view that it is better for the Electoral Act to be amended to leave pre-election matters arising from primaries for the political parties to resolve. In other words, it will be the responsibility of the parties to determine their candidates for election. I'm mindful of the fact that some powerful politicians do not allow internal democracy, but will impose candidates of their party. In such cases, provision should be made for the review of such cases in the High Court only, without appeal to the higher courts. In conclusion, I said that the courts have a very important role to play in general elections and electoral process in Nigeria or anywhere where there is democratic rule, to ensure that the validly elected officials constitute the legislative and executive arms of government following transition from one dispensation to another. I want to add that I have been very involved in election matters right from 1979 at the tribunal level, and then at the Court of Appeal level, and to the Supreme Court level. And this is one of the most important roles of a judge, to have to decide who rules in the country. And I used to shudder at the responsibility placed on judges, something decided by millions of Nigerians, like the presidential votes. Then just 7 judges or 5 judges in the first instance and 7 at the Supreme Court will determine the fate of the whole country. It should be done with the utmost care and not do anything that will cause chaos and constitutional crisis in the country. Thank you for listening.
Thank you, my lord, so much for your presentation. I would have loved to review a bit, but we have our next speaker is on his way to his way to the airport or en route, so we would just take him as soon as we can. Did I unmute you, sir?
Yes, please.
Okay, yes, thank you.
Thank you very much.
Thank you so much,
Thank
sir.
you.
Thank you.
My lords, the convener and members of this webinar, good afternoon. Let me apologize firstly, by virtue of the work I do, I'm quite very mobile. I'm inside the car now running off to the airport, but I'll try my best to do justice to this topic. I must acknowledge Justice Okebe in a very special way. I was privileged to be the lead counsel in the Ladoja matter before His Lordship at the Court of Appeal. Interestingly, before the matter got to the Supreme Court, His Lordship had been elevated to the Supreme Court, but he did the landmark matter in the Court of Appeal in Ibadan. My Lord, well, good afternoon to you, sir. And you are still looking very, very good at over 80. I pray I will be the same going forward. I must thank the convener for this very thoughtful webinar coming at this very time. I think that the survival of any country depends on democracy, and not only democracy on good governance, but good governance can only come and democracy will be sustained when the electoral system is credible, is acceptable, is welcomed by the citizens. And importantly, post-election disputes must find a way of being settled in an acceptable manner by the judiciary. I must say that I adopt all the things said by our ambassador and all the very good points made by my Lord, Honorable Justice Okebe. I'm not going to go over those ones because he has laid out everything succinctly. I just want to say that the grounds upon which you can challenge an election are well laid out in the Electoral Act. Principally, there are 3 grounds. You can challenge election on the ground that the person who won was not qualified by virtue of provisions of the Constitution that has laid down the qualification criteria to contest an election in our country, no matter the level, even from the local government. Number 2 is that such elections was afflicted by corrupt practices, which is a very generic and very wide area. And the third main ground is that the election was not conducted in accordance with the dictates of the law or the Electoral Act and the guidelines issued by INEC. Of course, I must be quick to say that when there is a conflict between the provisions of the Electoral Act and the guidelines or manuals by INEC, their lordships have made the point clear that the provisions of the Electoral Act will prevail because it is the substantive law under which those other manuals and guidelines were made. I also agree with His Lordship that election petition by its very nature is adversarial and it attracts a lot of attention by those who are knowledgeable about what goes on in the court, even those who are ignorant about. And it's very interesting that most Nigerians enjoy what I call the rumors of the construction sites and marketplaces when it comes to electoral matters. Everybody claims to be experts, even when they don't know exactly what goes into it. Broadly speaking, election matters are decided based on the facts and the law, as His Lordship had rightly pointed out. And I must say, and I join His Lordship in saying that when, in all, for example, for a presidential election, only 12 men will determine the fate of the failure or success of the winner or the loser. That is 5 justices at the Court of Appeal and 7 justices in the Supreme Court. And like His Lordship rightly said, if 12 people will have to pretend over what millions of Nigerians, at the last election, for example, we had over close to 30 million people that voted. Now, if only 12 people will now decide whether those about 30 million people are right or wrong, then a lot of care is needed in making such a decision. And I must also say that technicality, because election petitions are sui generis, they are in a class of their own. So any misstep in the filing of the petition or omission to put things that the law says you must put, or putting things that the law does not expect, could be very, very fatal because it is technical in nature. And I must say that over time, the country has built up a body of lawyers who are accepted as being experts in the field of electoral dispute resolution. I must also say, be quick to say, that taking part at a conference put together by the NBA about 10 years ago, where we were looking at the possibility of employing ADR for election dispute resolution. How that will happen, we've not been able to come around it, but I do hope that going forward is something that is achievable and that we can also deploy instead of just going to court. His Lordship had given us all the parameters for and the court system that, and I just wanted to add that for governorship election, for the legislative elections, both at the federal and state levels, you have two levels of, for the governorship, you have three levels of court system. You have the tribunals, you have the Court of Appeal and Supreme Court. But for presidential elections, only two levels of the court system are involved. The Court of Appeal sits as the tribunal for the presidential election, and the destination is the Supreme Court. So I believe quite honestly that for us to get a democracy on proper track and traction, the most important thing is to have credible elections. I believe quite honestly that the more transparent and credible the elections are, the less there will be resort to litigation to settle election disputes. I must also acknowledge one peculiar thing about our country. We don't, the spirit of sportsmanship is absent in our electoral, within our electoral gladiators, those who contest the elections. And I'm happy, I can also recall one or two cases where the Honorable Justice Ogebe had admonished the political class that they must know that when you go for an election, there will be a loser, there will be a winner, and that the spirit of sportsmanship must be displayed. I think that this is quite very crucial because the ability to be able to concede this defeat, even when you know that you have lost, is the spirit of sportsmanship. And this will also reduce to a large extent. And you all recall in 2019, because President Jonathan conceded, there was no presidential litigation in 2019. So I think we must also appeal to our compatriots that the spirit of accepting when you lose or when you win is very important. And lastly, being a fledgling democracy, we must learn how to play inclusive governance. Because those who lose, they think they will be shut out for 4 years. It promotes a lot of desperation to want to go for litigation and go all the way to do whatever you can do to undo what the electorates have decided. So I think running all inclusive governance and government at different levels will also ensure that the volume of the dispute after election will be reduced. I agree with His Lordship that pre-election matters. In fact, as I'm speaking to you today, the number of pre-election matters that have clogged our courts, from High Court to Court of Appeal to Supreme Court, is quite humongous. It's in thousands. And I think these are taking away the courts from their normal duties of attending to other cases. So I think we may find a mix of a solution from the suggestion of His Lordship. Maybe we can then try to develop this ADR model to deal with election matters. Since it's internal within the parties, they should be able to appoint people who they may have a law that will back it up. So who can be attending to those species of pre-election issues. This is my take, and I think that essentially, His Lordship had laid everything bare in terms of the technical areas of what is involved in our elections, pre and post-election disputes resolution. I thank you very much for this honor of being allowed to make this presentation, even though in this manner. Thank you very much.
Thank you so much, sir. We appreciate it, and we wish you journey mercies. Thank you.
Thank you very much.
So we'll go, I'm hoping that he would still be around for the question and answer. So we would quickly go to the next speaker. We would go to Justice Onum. Justice Onum, please. Justice Onum, please, could you unmute yourself, sir?
Okay. Is it all right?
Yes, sir.
Okay, thank you very much.
Yes, sir.
Good afternoon, everybody. Let me stand by the protocol that has already been established. When I received a call to participate in this webinar discussion, I expressed some reservation. After close to 5 years in retirement, and still resting in some unfamiliar ground, I do not consider myself as among the best choices to handle the topic. The convener, however, felt otherwise, so here I am. Before I go on to discuss the topic, which is very important, let me pitch my tent with the worthy initiative in honor of the erudite jurist, Honorable Justice Nikki Toby of blessed memory. It was indeed one of the colossi that bestrode the judicial space of this country while alive, and by extension, universal jurisprudence. I also doff my hat for the lead presenter, Honorable Justice James Ogebe, retired FRCON, a very cerebral mind whom I have known from the days of my infancy in the practice of law, to be an avowed advocate of precision and few words. The good starting point for this discussion lies in the truism that all the fundamental rights enshrined in Chapter 4 of the Constitution of the Federal Republic of Nigeria, 1999, are the handmaids of democracy. In this truism lies the right to aspire to political offices and to ensure the aspiration, to secure the aspiration with the right to seek for judicial intervention to avert any breach of the rights. For the same reason, our Constitution and laws approximate the duty of interpreting and ordering compliance with all laws to the court. The topic that I'm excited to speak on, that is court's role in the electoral process, is a straightforward one. It does not require much conceptual clarification. Straightforward because the target audience knows what the court is, except to say that the word court here also refers to the election tribunals established by law to determine disputes arising from elections in the country. The target audience also knows that what the interrogation means by electoral process. In discussing the topic, one must resist the temptation of delving into the activities of the electoral body itself beyond where any of such activities becomes an issue before the court of tribunal. Election process in this country can be divided into two broad segments: the interactions between the political parties and the electoral processes on the one hand, and the interface between the electoral process and the judicial system on the other hand. Our focus here will be on the latter segment, which can also be subdivided into pre-election disputes and disputes arising from the mainstream of the elections themselves. Section 285 of the Constitution sets the stage for the courts to tribunals to first prioritize attention to election disputes. The members are appointed by the President of the Court of Appeal. Section 139 of the Constitution invariably vests first instance jurisdiction to hear and determine disputes arising from the traditional election, and the Court of Appeal and directs the National Assembly to enact an act to provide therefore. The various provisions confer exclusive jurisdiction on the respective tribunals to exercise first instance jurisdiction to hear and determine disputes arising from respective elections in the country. Appeals lie from the decisions of the tribunal appointed by the President of the Court of Appeal on the presidential election to the Court of Appeal and then to the Supreme Court, while the desire is for the decision of the Court of Appeal to be final in regard to governorship and legislative houses in order to reduce the burden on the Supreme Court. It is hoped that necessary alterations to the Constitution be made in this regard soonest, if not already done, admitting that I have been out of touch with such operations for a while. One obvious challenge that we face in this country as we engage in elections regrettably lies in the obvious fact that most electoral office seekers see the offices to which they aspire more as opportunities for primitive, vigorous acquisition and accumulation and amassment of wealth, as opposed to that of rendering service. They therefore go all out to do things that are only deceptive in outlook as to what the post-election period really holds for the electorate. False promises become rife in political party manifestos. Integrity in the electoral process becomes a big challenge. It is in the effort to override these improprieties that the judicial powers vested in the court by Section 6 of the Constitution of the Federal Republic of Nigeria comes to play. The courts are expected to act as the clearinghouse where applicable laws, guidelines, etc. are interpreted as guides, not just for the election in hand, but also for all future elections to ensure that the collective will of the electorate, as expressed through the polls, takes the center stage in decisions that are transparent and readily amenable to understanding, even for the ordinary mind. And is expected to generate and sustain public trust in the judiciary. Unfortunately, the more pronouncements the court make on gray areas of our electoral process, electoral laws, guidelines, etc., the more our politicians seek to circumvent the processes by cutting corners to introduce more complexities. It is to say that electoral processes can never be perfect in this country, and so the need for judicial intervention is going to be a continuous process. In exercising its judicial powers, the courts are expected to operate within the exclusive brackets of the Constitution, laws, and rules, carefully put in place to ensure that substantive justice is done in every case brought before them. For instance, the courts are by now sufficiently cognizant of the fact that election petitions are sui generis and a technicality anathema to the process of justice, concept of justice, even though it may be hard to, at times to distinguish between technicalities and mandatory requirements of the law. The courts have not left the system in the cold as to what constitutes technicalities, even while pursuing or pushing for the firm stand that it is always better to err on the side of according litigants a hearing on the merits in every electoral dispute brought before them. This is so even in the face of non-compliance with some technical rules, either in commencing or prosecuting an election petition. In the cases of Akeredolu and Abraham, the Supreme Court says of the danger inherent in technicalities. And I quote, technicality in administration of justice short as justice. A man denied justice on any ground, much less a technical ground, grudges the administration of justice. It is therefore better to have a case heard and determined on merit than to leave court with fears of victory obtained on mere technicality. Further on the crucial point, in our judicial criminal electoral process, the Supreme Court says in Aliu Bello against Oyo State, I quote, "The picture of law and its technical rules triumphant and justice prostrate can no doubt have its admirers. For the spirit of justice does not reside in form, formalities, nor in technicalities, nor in the triumph of the administration of justice, to be found in successfully picking one's way between pitfalls of technicality. Law and its technical rules ought to be the handmaid of justice." The good news is that the courts are now sufficiently equipped to ignore technicality so that every election petition can be heard and determined. It might be quite easy to imagine that allegations of corrupt practices is rise against judicial officers who sit on election petition disputes. It may have led to the downward score on the imaginary of the impression public in some areas, some cases. With every sense of responsibility, I do not see how the appearance of corruption per se can define the outcome of a judgment, knowing that appeal lies to the higher courts where the judge's learning will be tested, or to the court of public opinion where there is no right of further appeal. In my thinking, the judgment of any court is a product of the learning of the judge. For that moment, it is hard to see how any judge would want to compromise his own integrity due to over the years, just on account of some favor from the litigants before him. The good news again is that appeal processes are available for clearing down to the highest court of the land. Agree that in some cases the courts have only been cajoled in courtroom trespassers by lawyers into making conflicting orders to give the impression that such courts have become politicized. This became so prevalent at a certain stage to warrant an extrajudicial intervention by the Chief Justice of Nigeria. This was when the High Court in the states of Rivers, Kebbi, Cross River issued different conflicting orders on the suspension of the former chairman of the People's Democratic Party, Mr. Uche Sekondo, from office. The CJN had to admonish the chief judges of the respective states, and indeed all the states, to keep close watch over their judges to ensure that the incident of issuing conflicting orders no longer rears its head in any jurisdiction. Such cases either reflect on the learning of the particular judge or on acts of outright impropriety on his part. I've already noted the judicial officer who is worth his name and office may not want to twist obvious facts or the law just to ingratiate the personal loss, knowing that appeal processes are readily available, options where his learning integrity is put to test. One other obvious outcome of judicial intervention in our electoral process is the fact that gubernatorial elections have invariably become staggered in some states, such as Anambra, Bayelsa, Edo, Ekiti, Kogi, Ondo, and Osun. In those states, owing to the success of election petitions in those states, election petitions for those states, the electoral body now enjoys the uncommon comfort of organizing elections without the usual challenges associated with security and timely distribution of electoral materials. I see this as a positive impact in the very narrow sense that the electoral body has become well equipped to organize a more reasonably flawless election in the state. The recent decision of the Supreme Court in the cases involving nominations the present Senate President, Alfred Lawan, and Senator Godwin Akpabio, to contest the 2023 elections will continue to generate arguments, given the fact that there were some strong dissenting voices in the judgment, which dissenting voices are clear pointers to the fact that it's not here to rule for a democracy when it comes to need for judicial intervention. The good news again is that the Supreme Court has the inherent power to be dynamic in the exercise of its jurisdiction, bearing in mind that it is the final arbiter in any dispute brought before it. Once it reaches a final decision on any matter or issue, any restiveness on the part of the electorate is brought to absolute submission on such matter or issue. Honorable Justice Soputa retired, Jersey retired, made a point of the finality, the exercise of its inherent power in the case of Adegoke Motors against Adesanya. But the learned juries pointedly say, and I quote him, "We are final not because we are infallible, rather we are infallible because we are final. Justices of this court are human beings capable of erring. It is certainly the short-sighted arrogance not to accept this obvious truth. It is also true that this court can do inestimable good through its wise decisions. Similarly, the court can do incalculable harm through its mistakes. When therefore it appears learned counsel that any decision of the court has been given to incurium, such counsel should have the boldness and courage to ask that such a decision be overruled. The court has power to overrule itself and has done so in the past. It gladly accept that it is far better to admit an error than to persevere in it, in error. End of quote. The court has used the power to settle high-profile election petitions. The court has used this power to settle high-profile election cases, such as governorship and presidential election petitions. That gives the assurance that in our political process, we will not persevere in doing the wrong thing. The courts are at the tray of politicians in their uncanny manipulations of the electoral process with the aim of totally eliminating or reducing them to the barest minimum in the country. The last election is bound to record a significant improvement over previous ones in the narrow sense that pre-election disputes are no longer part of the election disputes themselves. The court has assiduously worked and sorted out all pre-election disputes before the election. The deployment of technology by voter accreditation systems to beavers, machines, and INEC results viewing portals to IRS and the electoral body INEC have, however, opened up new phases of controversy in the electoral process that are yet to be judicially tested. The guidelines issued by the electoral body itself provide for the exercise and use of the devices platforms, for the existence and use of the devices and platforms. So it can neither claim to be ignorant of the devices and platform, nor righteously refuse to use them. In the instant situation, people have cried foul over either the malfunctioning of the beavers machine, the failure on the part of the electoral body to instantly upload the election results to the server. In suit number FHE/CS1454/2002, before the Federal High Court in Lagos at the instance of Labour Party against INEC, decided on 23rd of January 2003, the court dismissed the prayers for orders compelling the electoral body to electronically upload the results of the presidential election and not otherwise. There are other complaints that have become traditional in every election in this country. It is not unlikely that the doctrine of substantial compliance, which is now in line with Section 135 of the Electoral Act, and which the courts have leveraged upon over time, will continue to hold sway in deciding most of the decisions that will arise in the petitions. Perhaps owing to the unwieldy or amorphous nature of the constituency in the presidential election in the country, no presidential election have been successfully prosecuted. See the cases of Awolowo, Shagari, Falaye, Obasanjo, Buhari and Obasanjo, Buhari and Yar'Adua. In all these cases, the petitioners were not able to prove lack of substantial compliance with the laws and guidelines relevant to the respective election. This is to say that proving substantial non-compliance is always an uphill task, especially in presidential elections. Certain fundamental issues that bear on the conduct of electoral officers have also been finally settled by the Supreme Court to give a sense of direction to the electoral body, tribunals, parties, some sense of direction. A further example will suffice, a few examples will suffice here in view of the time limited for the presentation. On who has the right to cancel polling results at an election, the court by Galadima JSC said in the case of Ifeazu and Oti, and I quote him, beyond arguments of prospective counsel on this issue, the law has been fairly settled on whose responsibility it is to cancel an election result. The two lower courts are adherent on this. It cannot be disputed either that the appellant and the respondent here were in agreement, as well as the trial tribunal that the state returning officer had no power whatsoever to cancel polling results. The state returning officer has no power whatsoever to cancel polling results. In the case of Doma against INEC, the authority to cancel election results came up for consideration. In the case, CW3, who was the collation officer purported to have cancelled results of the election, as against DW9, who was the presiding officer at the presiding union. The court did not only hold that the state returning officer has no power in law to cancel election results, but duplicated his court doing so, end of quote. On the ground upon which the outcome of an election may be challenged under the Electoral Act 2010, Toby JSC of blessed memory had said in the Ojukwu and Yar'Adua, and I quote him, the petitioner is required to question an election on any of the grounds in section 145(1) of the Act. He is expected to copy the section 145(1) ground word for word. I think the petitioner can also use his own language to convey the exact meaning and purpose of the subsection. The alternative to the situation, the petitioner cannot go outside the ambit of section 145(1) of the Act. In other words, he cannot add to or subtract from the provisions of section 145(1). In order to be on the safer side, the ideal thing to do is to copy the appropriate ground or ground in the subsection. The petitioner who decides to use his own language has the freedom to do so, but he should realize that he's taking a big gamble, if not a big risk, end of quote. On the propriety of dismissing an action, including election petition in limine, the learned jurist, Toby JSC of blessed memory, again said the case of Inakoji against Adekeleke. Dismissal, and I quote him, dismissal of an action in limine is the most punitive relief that a court can grant a defendant against the plaintiff. Because of its punitive nature, courts of law are reluctant or loath in granting it. In other words, courts of law cannot grant the relief for the mere asking on the part of the defendant. There must be legal basis for the request and corresponding legal basis for granting it, end of quote. The aim of these and similar decisions is to whip all active participants in the electoral process into line so that they do not persevere in doing the wrong thing. In summation, the courts are positively impacted on the democratic process in this country. By the free exercise of the power of judicial review, the court can and have indeed controlled every facet of our democratic process. As the necessary incidents of these elections in the country will continue to be subjected to the fiery sieve of judicial process power, it will continue to be a learning process, with the judiciary always in tow to settle all disputes arising therefrom. In other words, the need for judicial intervention is likely to continue to exist alongside every election in this country. Actually, we are a country of tremendous respect for judicial processes, including others. Once a matter is brought to court or settled to finality by judicial orders, frayed nerves are calmed and losers settle to lick their wounds while waiting for another opportunity to join in the contest. In all, everyone will score the judiciary of this country way above the average, promoting the ideals of democracy. Thank you for your attention. God bless you all.
Thank you so much, sir. I appreciate you, my lord. Thank you for taking your time off your vacation and retirement, indeed, to grace this occasion. So we will go right to the next speaker.
My lords, good morning or good afternoon, and all invited guests. Let me start by acknowledging Justice Ogebe and the enormous work and submissions that he made, which I think set the tone. It's been a while since I've seen him, so it was quite exciting to see him yet again. I want to also, but more particularly, let me thank Ari for giving me the opportunity to share my thoughts on this topical, apt topic, because we have just emerged from elections, and I know that on the hearts and minds of most of the electorate, and in fact citizens, there's a lot of anxiety, there's a lot of tension, and it takes courage and boldness to speak about life issues when you have the opportunity. So I want to congratulate the organizers of this this program, and as I said, particularly Ari.
Thank you.
You're welcome. I think it would be nice for me to let's start from the fact that all lawyers, and when I mean all lawyers, the judges, the justices were first lawyers, and before they chose to take that route, which is that of the judiciary. But all lawyers, judicial officers, have a duty to promote the rule of law, to uphold justice, and to maintain a high standard of professional conduct. I think it would be also worthwhile to highlight the fact that one of the key elements of the rule of law include, first and foremost, the supremacy of the Constitution, certainty of laws, which would enable citizens predict the outcomes of their suits, and the existence of an efficient and independent judiciary. Today, we are examining the role of the judiciary in Nigeria's electoral process. And of necessity, we would not, in my opinion, I wouldn't attempt to assess their performance, but rather to highlight some of the roles that, some of the things that could help us achieve a more stable, a national unity and security in our nation. I think at this juncture it would be worth talking about the importance of the judiciary in Nigeria's electoral process. Of course, by virtue of Section 6 and all the other relevant sections, the power of the judiciary as an impartial arbiter cannot even be defined. However, owing to the fact that the process of elections produce change in government, produce change in leadership, compel accountability, and should afford participation and inclusiveness, and also vest the electorate with sovereign powers. It becomes very, very critical and important that we take seriously and pay attention to the role of the judiciary. Justice Egebe had laid out the procedure because, of course, elections are more often than not, when you talk about elections, some people think it's just the polls. No, it isn't. Of course, you have the pre, which will cover sponsorship, the primaries, and all of that on the one hand, and then the polls actually on the other. Therefore, the role of the judiciary is of critical importance to the stability and development of Nigeria. Also of critical importance is the fact that the judiciary, the courts are seen as impartial arbiters, and therefore their competencies are purely impartial, and the purpose is to achieve justice or to attain justice. But I think at this initial stage, it will be worthwhile to say that although the judiciary is one of the guarantors of free, fair, and credible elections, you have the executive on the one side, you have legislature on the other, and you have the electorate itself. And while the anchor, because ultimately, like where we are now, we have the pre-election phase have gone by, and that is, like I think it was Malam Ali mentioned, just the sheer number of cases that had to go to court and distract the courts, which is on the one side. You also have now everybody's preparing because, of course, the Constitution provides for when with the time within which you should file your petition, and the tribunals have been set up. And but if at the stage we are now, Nigerians, everybody's eyes are on the judiciary. Why? They have done the politicians have done their bit. The electorate has done its bit. They voted, and the executive, the management, election management bodies, i.e. INEC, have done their bit. With all the promises that were made, of course, there's a lot of complaints and a lot of dissatisfaction and a lot of observations and comments which appear to impugn the work of the election management bodies. But we are thankful to God that things did not degenerate to a point where there's violence. Everybody has, I still believe that because of the confidence that we have in the judiciary, all the parties that feel entitled, and of course the law has listed who can file a petition. Obviously, it will be the party itself or the political party that sponsors. Those are the only two. And it has also, the law has gone ahead to provide the grounds upon which you can challenge the elections. So, of course, if it has to do with qualification, if it has to do with wrongful, if it has to do with corrupt practices, if there is a non-compliance, the three grounds are clear. So, of course, and like was said, elections are sui generis. They are unique, and the procedure is fixed and is known. That is why we look forward to collating the various recommendations which I found most inciting, and which would help us to come to at the end of this exercise, be able to make recommendations which I hope that Nigeria as a country would pay attention to. In my paper, I highlighted the applicable laws, of course, the Constitution, the Electoral Act of 2022, the Electoral Regulation Guidelines of INEC, the Election Tribunal and Court Practice Directions, the Civil Procedure Rules of the various courts, and other relevant statutes. So the onus is on the judiciary, on the courts, to apply, to interpret those relevant and applicable laws and apply them to the facts. The role of the courts in Nigeria electoral process is crucial for several reasons. The court's constitutional and inherent power is to interpret and apply the law as well as the Constitution. It ensures that disputes arising from elections are resolved in a just and timely manner. This helps to prevent violence, tension, unrest that can arise from unresolved election results disputes. We have seen the reaction, and in fact, my lords have referred to cases which up till now, we cannot really understand the rationale, and which is why it is critical for the judiciary to be able to deliver judgments that the outcomes are predictable. They should be predictable because the law is known, and all that is expected is if there's non-conformity, the courage to decide in a way that will reduce the negative perception. However, I would like to say at this juncture that Justice Mahmoud Mohammed said, and I quote, "May I start by observing that allegations about corrupt judicial officers and staff now make headline news on a more frequent basis. On the allegations, senior members of the legal profession are also being accused of allowing themselves to be used as conduit pipes for the corruption in the judiciary. Although I will not behave like the proverbial ostrich and hide away from the reality that some judges and judicial staff are indeed complicit in corrupt practices. However, I must assert that corruption within the judiciary is only limited and imbibed by a minute minority. End of quote. I want to believe that that is actually the position. And because a lot of the discussions that go on, especially at the media, do not actually understand the legal implications, and sometimes they don't even ask questions. There's a lot of sentiment that is bandied around, and as a result, there tends to be comments that are sometimes totally unjustified and sometimes even reckless. The role of the court is meant to build confidence in the democratic process. When the electorate see that disputes are being resolved in a just and timely manner and in accordance with the provisions of the law, they are more likely to have faith in the electoral process. Because the reverse is apathy. A lot of people do not bother to vote because they feel their votes will not count. I want to believe that the INEC did a good job of boosting the confidence of the electorate. And so a lot of people, more people than you would have expected, came out believing that there will be no issues. In fact, some comments were that for the first time in a very long time, the elections appeared peaceful and all of that. But the issue, and that's where the judiciary now comes in. The issue is having voted peacefully, apart from some areas, of course, which have been highlighted. It was, we noted, in fact, the electorate expected that there will be no issues because of the introduction of the technological devices. The general comment is not that the technological devices did not work, but the issue is, were they used, were they deployed as they were meant to be deployed? Now, since these are live issues, I will not go further, but suffice it to say that this is where I believe the independence of the judiciary, the integrity of the judiciary will be tested, because especially in the area of technology, it is scientific in the facts that you are giving. Did you deploy it? Did you not deploy it? What did INEC prescribe as the method, as the procedure for conducting the elections? Now, it is either they complied or they did not comply. So unlike most other elections where we are talking of ballot box stuff and snatching and stuff and snuffing and whatever else, we are now in a different, it's a totally fresh terrain, because the question that will be asked is on non-compliance is straightforward, but it will take courage. It will take guts. It will take integrity to apply the rules, to apply the law to the facts, or vice versa. And I know that the world is watching and the world is waiting. So I want to congratulate yet again the organizers of this, because like was expressed, I think by one of the, by my lord. When I saw the topic, I wondered, my first question was, it's so live that is it a safe thing to do? But then again, it is safe. Why? Because we need credit for us to develop as a country, for us to reduce tensions, for us to advance security, there must be fair, free, and credible elections. And the only way that will happen is by non-compliance of, by compliance with the rules which have been laid out, and the procedures prescribed. So there are going to be critical questions that will need to be asked. Can INEC, for instance, continue to change the goalpost at will? I love the fact that my Lord said he didn't want to be an ostrich. This exercise gives us an opportunity for us not to be ostriches. Why I have virtually abandoned what I wrote is because, what I thought I was going to be talking about is because I don't want to bore the audience, the esteemed audience. I don't want to repeat what has been said already, but I think that the heart of the matter, really, when the chips are down, after all the players, the security operatives, the National Assembly, and by the way, I don't know how it will be possible for the National Assembly to stop this 4-year cycle of amendments of the Electoral Act. I find it obnoxious, and I tell you why. You can see that more often than not, what is amended is for a particular person. So it's a bespoke amendment, and not in the interest of the whole of the rest of the electorate. The electorate they have the sovereignty, they have the power to determine who leads them. But they are frustrated. Like, for instance, it was on TV when they showed the boys who were playing football. The week when we had the presidential election, everybody, the people stood in the rain, people stood in the sun, people were, they wanted to vote because they knew and they believed that their votes would count. Now, I can see the proverbial description that the court is the last hope of the common man. The common man has given up. That was why they were playing football during the governorship candidate because election, because they felt there was no point. But I want to believe that we have an opportunity in our judiciary, and that is why I keep saying that this topic is apt, because that is the only opportunity for justice, equity, truth to be told. That is the only way that we expect, if there are facts to show, that indeed there was non-compliance, then of course we believe that the court will decide correctly. The primary duty of a judge is to do justice in the matter before him without fear or favor, affection or ill will. The judge must stand above court and maintain the confidence the parties in the matter repose on him. The judge must free himself of prejudice and partiality. Election petitions are by their nature sui generis and peculiar from the point of view of public policy. It is the duty of the judge to endeavor to hear them without allowing technicalities unduly fetter their jurisdiction. The judge is not only to do justice, but substantial justice. The judge has a duty to speedily dispose of election petitions so as to serve the interest of justice. I would maybe touch on, because when I was, I reflected and could not but acknowledge or notice that there is a lot of misgivings and a perception that is not all the time very creditable. I felt that it might be fair to also mention some of the factors that may hinder the performance, the optimal performance of judges. I've mentioned that there appears to be an emergence of corruption in the Nigerian society on a grand scale. Interference at different levels of government in the appointment and promotion of judges and justices may be responsible. And I do recollect that after late President Yar'Adua's elections, he set up a review panel that was headed by Justice Ewes. And those recommendations were valid, are still valid. And so we don't have to invent the wheel. All we need to do is go back and check, go back and see whether some of the recommendations can be implemented and implemented. As a matter of fact, CONFAB also provided yet, that's 2014, provided yet detailed recommendations as to the appointment, the agency, the setting up of an agency, the issue of tribunals being the sole responsibility of the president of the Court of Appeal. These are all issues that were raised. So sometimes when we are invited to speak, we wonder whether we should continue to regurgitate the same thing that we know already. I want to believe that we all know what is right. And I also want to believe that as a nation, we have had a lot of review panels. We have had, so in terms of those recommendations, they exist. It's now the will to implement them. Former Justice Mohammed Ewes, in his review committee, suggested that there should be an adoption of independent candidacy and the procedure for appointment and removal of INEC, the INEC chairman and members of the board should be reviewed. He also suggested that they should increase the number of election tribunals. They should shift the burden of proof from the petitioner to INEC to show on the balance of probability that disputed elections were indeed free and fair. Adoption of specific procedural rules made for election petitions. It has then, I've mentioned already the fact that there are a lot of recommendations that were made during the CONFAB. I also think that we can, hello?
Yes,
basically, to allow the electoral malpractice, violence, and consequent political apathy and disenfranchisement to pervade and pollute a democratic system would be to rob all citizens of their fundamental rights and our nation's collective legacy of potential greatness. I say potential greatness because Nigeria is great, should be great. But in the eyes of the rest of the world, when things like this happen, and comments that are negative are made, or perceptions that are negative are made, it's unsettling and disturbing. I want to say, as a senior member of the board, that I have absolute confidence in the judiciary. Indeed, there are areas that could be improved upon. And I also believe that there are templates that could be created, especially with pre-election matters. It's straightforward, almost scientific. We should by now be able to even get rid of some of these pre-election matters in the shortest possible time. It was suggested that maybe ADR alternative dispute resolution mechanisms should be deployed. And I never thought about that, but yes, it is possible. But the fact is that cases, generally speaking, in courts have been so delayed because of the inundation of pre-election matters in the high courts. Sorry, in the high court and the federal high court. And of course, because of the tribunals that have been set up, that means all the matters that those judges and justices were involved in would have to wait until the matter is resolved. These are delays that we could avoid.
The last but not the least speaker would be Mr. Kunle Lawal.
So good day, everyone, on all existing protocol. And I must first say thank you very much for granting me this opportunity. I'm here in the midst of a lot of legal folks, so I'll try to, the talk has been a little over-structured, and I'm the one that's officially not a lawyer. I'm privileged to be in this conversation. So I'll try to, how do I put it? Let's break the ice a little bit. So I'd say the only thing that gets me close to law is the fact that my first name is Justice. I don't know, for whatever reason my parents decided to name me that, but I think that gives me enough premise to sit down in this conversation. And it's a very good topic, the courts and elections, because the truth is Nigeria is such a complex nation, and when everything goes on, we finally get to this point where, we get to a point where most people are aggrieved because we're mostly concerned about the product and not concerned fully about the process. Hence the weight of what the judiciary and the courts have to do in every election cycle. So the 2023 election, about 87.3 million registered voters. Sadly, less than 25 million participated in the elections, and that's at presidential level. It drops to about 17 million in gubernatorial elections. Now, of course, looking at the whole thing, elections, of course, starts with the registration of voters and ends with the conclusion of judicial adjudication over disputes. As the petitions get to courts, we hope that the gray areas in our electoral laws can be made clearer. And I'm very interested in this point. So most of the problem that occurs in Nigerian elections starts even preceding the elections. And if you've seen, especially within state and gubernatorial elections, a lot of problems emanating from these cases always emanate from the primaries. That is pre-election, as my mommy put it, Sadisan, Leonard Silk. So pre-election is very important. And I think key among most petitions in elections, mostly pre-election. So like I stated earlier, we're mostly concerned about the product, which is who we are electing, and never the process of how it's elected. Now, fortunately or unfortunately, the Electoral College Nigeria, our review on the 2023 elections came out today. And one of the key things, we would like to bring up, because we are so focused on political literacy, we cannot do this without, the Constitution, the Electoral Act. And that's where political parties miss it, or politicians in general miss it. It's like asking them for too much, because the average politician doesn't even go through his party manifesto. I remember a certain governor who switched parties, and when asked, did he switch because of the manifesto? He said he's a new member and he has not got to look at the manifesto yet. So he didn't switch because of that. Then why did you switch? And these are the problems we have within politics in Nigeria. I would say most interesting, I think the onus is on a few of us that have given themselves to political literacy on ensuring that the average Nigerian understands the Constitution and the Electoral Act. I think this is very key, and this is necessary, because as it seems that the problems that we have emanate directly from the fact that we do not even know what to expect in an election or how an election process should actually go. What we've done in Nigeria is directly build a so-called culture from what exactly should be the law. So we've built a culture, and I've accepted that culture, and it's become a way of life for us in politics, and hence, the courts. I'll tell you, within our review, one of the key things that came into prospect will be we are interested in understanding the interpretation of the Electoral Act, section 95(2), and it states clearly that state apparatus, including media, shall not be applied to the advantage or disadvantage of any candidate. But we have a case where an appointed executive serves as a campaign spokesman. This is a gray area that hasn't been focused on. The Electoral Act is also very clear about campaign financing. We're looking at 5 billion for president, 1 billion for governor, 200 million for Senate, and coming down. These are things that are law in Nigeria. Are they being enforced? No. Do the people know? No. It's a whole, prospect. So these things are abused. I'll tell you how far it goes. So preceding an election, I think it is, let me look for the exact section. Give me a second. I think it is 773 of the Electoral Act 2022. It clearly states that political parties must submit their physical, that's their hard copies and soft copies of its members across the country before, and this is law, before they proceed to conventions and congresses. Now, clearly, the Electoral College, which has been following all this, we clearly know that of the 18 political parties, nobody met this criteria fully. But nobody's engaging on those parameters. Nobody's asking those questions. Nobody's talking about election finance. Nobody's talking about, okay, now the arbiter, INEC, who of course, according to the law, has rights to choose what, and I'm very clear about us looking into how INEC now, INEC should operate and reviewing it. Because INEC comes out to tell you that we're going to ensure that the polling units directly to the servers of INEC, Beavers, will send these results. You spent 6 months telling Nigerians that. You went outside the country, went to BBC, you told them that, you marketed that. You spent 100 billion naira of taxpayers' money on that particular thing. And then you wake up and say, no, we decided to do it manually and I have the power. I feel someone should take INEC to court for misleading Nigerians, if not for anything else. I don't know, but lawyers will have the correct words. But they naturally, and they spent our money, our personal money on this. I feel, like I said, we're very concerned about the process than we are about the product. Most of our problems come from pre-election matters. And of course, there are those post-election matters, which of course come with, issues and whatever. But, I'd like to delve into something which most people would not want to hear. I'm sorry, I don't mean to offend anyone, but, let's talk about the issues as they are. We're not being ostriches here. So one thing I like to dabble on is the perspective of Nigerians about the courts. And I think lawyers should know this. The average Nigerian thinks or believes, not thinks, believes is a better word, that, of course, the courts are financially induced. Secondly, a long time frame for outcomes. Thirdly, a seeming tool for incumbency. And I would explain this particular line. In the case of, so the Electoral Act states that in this present dispensation, from now on, you cannot vie for a particular political office in one election cycle and then change gear, not in those words, I'm just simplifying, then change gear into another political office in the same electoral cycle and you're granted a ticket. This happened with a senator in Akwa Ibom and someone, I just don't want to call names. I know, I just don't want to call names. So a senator in Akwa Ibom and then someone who is the presiding officer in one of the National Assembly houses. It doesn't make sense for something that's written clearly in English and a court passes another judgment. You are directly discrediting the entire judiciary, the work of other lawyers, respectable lawyers who have put in quite a lot. And the electorate sees it from this perspective. There's no way you can twist or misinterpret that particular, part of the Electoral Act. But we have these situations occurring. And Nigerians seem to look at it and say, this is where I'm supposed to go to ask the right questions. But if they also are there in turning the key towards the direction of whoever can pay the piper or whoever can direct the piper in any case, we would have a serious problem. It is clear that beyond reasonable doubt, in Nigeria as relating to election matters, we have different strokes of the law for different people or different strata of society. I know there are a lot of great lawyers who I'm well in contact with, who I do not blame for this, but it is the perspective now being sold based on the political climate available in Nigeria. But I don't like to discuss problems without discussing solutions. I'm one of those who has postulated from when I was running for office in 2019 clearly that I do not believe that a president should appoint an attorney general of the Federation. I've never, because for me, it holds the independence. This is a country where I think police is under the Ministry of Interior. How is the judiciary going to be independent? Or how is it going to use its powers? Or we remember earlier a situation in where a president sent the police into the residences of Supreme Court judges or the DSS. How is the judiciary going to be independent at this point when the executive fully over-exercises itself and mortgages other people's power for its own use? I have always stated that the executive in Nigeria is more powerful than anyone anywhere in the world. And of course, when it has a legislative who apparently does not understand its direct effect on the executive or its maneuver on the executive, it's going to be a problem. We had a situation sometime earlier, and it's clearly stated in the Constitution that National Assembly can summon any Nigerian. But Nigerians say, or the executive says it cannot summon the president of Nigeria. How does that make sense? The president is a Nigerian, so it can summon any Nigerian. But Nigerians want it to have the Senate the National Assembly can summon the president. We're not serious in this country. Then we could as well just put in our laws, the president must brush his teeth at 9 a.m. Since that's what we want to write everything and write the whole process down. So solutions to this, one of the key things I think is that issue with the president and total separation of providing the independence of the judiciary. I think that the judiciary and courts need better communication, first and foremost. There are times when things, let's be honest, most Nigerians take decisions, being them especially political, from two major perspectives, emotional and nepotic. Those are the two major directions Nigerians choose things before the third, which is from a religious undertone. If the courts communicated better why some things happened in Nigeria, I think we might not have the quagmire and the point that the electorate generally thinks that most people in the judiciary are in bed with the executive or etc. Because some things, decisions in courts are mostly not taken from the eyes of the law. It's blind. But we need to be able to explain these things because we have as the Electoral College believes, and we've taken statistical power, an 84% politically illiterate society. You don't expect them, people that have never opened the Electoral Act, you want to expect them to understand the powers of INEC, powers of the judiciary, powers of the executive, powers of the legislative. It's not possible. These people are struggling with knowing more than 3 parties. If I ask the room to name 7 parties, I'm sure we'll be in a quagmire here. And that's where we are as a country. So if they can't name 7 political parties, are we going to start discussing the Electoral Act or infringements on the Electoral Act or the Constitution with people? So I believe communication is very key by courts and the judiciary to move Nigeria to a better place politically. We need to have more open court sessions. I think, no offense, but sometimes it seems like a cult. No offense, I don't mean that way, please don't take it wrong, but it kind of seems like that. I think we should have the situation where school children are invited, secondary school children are invited, just to see the process, to make law seem like, not the mystical thing it is in Nigeria, but, something that people want to aspire to. I also believe that the judiciary, in conjunction with, all other people trying to put things together, should endeavor on a mass action to teach Nigerians the Constitution and the Electoral Act. There's the uncommon belief, which, lawyers do not say, and I'm sorry if I offend any lawyers saying this, but they believe that, now everybody believes, including lawyers, that the Constitution is the birthright of lawyers. It isn't. It is the property of every living Nigerian. I call it the Holy Book of Citizenry. And that's how we should look at the Constitution. If you go to other countries, the basic Constitution, okay, Britain has a non-written Constitution. The US, children already can quote parts of the Constitution. I don't think that should be a bad thing happening in Nigeria. We shouldn't shroud everything in mystery or our profession or something else. And I also think the judiciary should start to take impressive acts to show its own independence by opening itself to the same people it is sworn to protect by the Constitution and its oath. I think these are solutions that would help. I know I'm the little boy in the room. I've been, as a cheetah, I've been put in a room with lions. I just hope I was able to tear a little bit of the meat for you guys to understand. Thank you very much. And it was a pleasure addressing you all. Thank you.
Thank you so much. Thank you so much, Mr. Lawal. Indeed, you have you've given us details of your experience in the Electoral College, and indeed we are very pleased with that. And so I would quickly recap what our speakers have said so that we would have questions. And so while Ugo and Liz will take questions, please send your questions to the tool, chat tool. The ambassador, Honorable Ambassador Tijani Bande, gave a very interesting dimension of his concern and his comments and his admonition on this topic. Talking about, first of all, of course, as an ambassador, he prides that Nigerians are doing extraordinarily well globally, and Nigeria is really heavily connected in the world on a number of issues and areas. But his concern on the ignorance displayed through the media is one that we would definitely put out there as a recommendation from this forum. He suggested that the people knowledgeable in the law and knowledgeable reporters should be involved in the way the media engages with the court. In quoting him, he says, it is important to communicate the jurisprudential basis for judicial decisions. And I'm sure that is also part of what Mr. Lawal is saying as well. How can we have courts, understand, come to that level of the society and use less legal terminologies and more of society-oriented justice? What does justice mean to the society, and how does the society understand the justice that you interpret? Then Justice Ogebe he stated the importance of the importance of the role of a judge, and said that the number of judges, of course, being there, done that, the number of judges that preside over cases from the Court of Appeal to the Supreme Court is such that, compared to the kind of cases that they hear, it is fundamental. And I think he's saying again that we decide these cases with extreme care, which was supported by Malam Ali SAN, that the country is in a place where we need to fight for democracy and good governance. He stated 3 grounds under which election petitions can be made, and this quoting very interesting. I found it quite interesting that most Nigerians engage in rumors of construction sites and marketplaces as it comes to electoral cases. They don't do research. They hear one thing and then tweet. Everybody's believing one lie or one unresearched information out there. And he's argued that absent of spirit of sportsmanship is one of the problems and challenges that he sees in the electoral process in Nigeria. Honorable Justice Onum, retired CJ, talked about the fundamental rights of the fundamental rights as the handmaiden to democracy. He stated that the electoral process is the way it is, and it's a challenge of the electoral process is because the candidates, those seeking office, have the wrong motive in going into office. They want to amass wealth instead of going there to serve. And he took us on a plethora of case law, which very insightful, and his paper will definitely be available when we eventually publish. And the Nelet Silk Rabana said that the hearts and minds of the electorate, the citizens, it's like there's a tension, there's anxiety, and that this forum is a way where we can elevate and maybe educate and encourage them, as it were. She said all lawyers, including judges, have the role to uphold the rule of law, and particularly I liked this part, and ensure high standards of behavior. I would also like to use that as part of our recommendations as well, that the judges would, in their decisions, mention and take particularly high standard of behavior. The United States of America no longer goes after leadership in terms of your degrees and your Ivy League and awards. America is now voting for character in the presidency. It's important that we have people who have standard of behavior. So the Electoral College is saying something about a simple compliance is a problem. None of the parties complied with a section of the law. We have to hold our people in electorate and public office seekers, candidates, accountable, and the court is where that can be done. It may be an arbiter, it may be a word that is just, eventually it will become the norm and it will become a principle or precedent. She indeed said reinforced what A.T.Socio-Judicial Consulting, I beg your pardon, does and is focused on, that we are not about here to assess judges' performance, but to achieve a more secure democracy. She quoted the ambassador saying, judges, we have, yes, maybe issues in the judiciary, but out of the 12, there is one Judas, doesn't mean that the other 11 should be crucified. We don't throw the baby and the bath water. And then we go straight to the last, but not the least, presenter who gave a raw situation on how he sees things from his perspective as the executive director of the Electoral College, and how lack of education, like the Bible says, my people perish for lack of knowledge. When we don't have knowledge, we are in a box. As the giant of Africa, as we are well known, Nigeria is strategic to influencing other African countries in the electoral process. It is important that we understand, he gave us statistics and, gave us bullet points. Of course, hopefully, I haven't heard from him yet, but if he has the time and he wants to make this a publication, we'd also have his publication out there eventually with the rest of them. But he has made it clear that we need education. And I would say he quoted, gave us their statistics, 84% politically illiterate Nigerians. And unfortunately, I probably am one of them. We need to be more educated on the electoral process. We need to read the law. We need to understand how we can, and who knows, maybe A.T.Socio Consulting would collaborate with the Electoral College on how to do free electoral classes before any elections and get the public involved. Webinars, maybe that's something that would come up, So that being said, I would like to ask for questions. If we have questions, it would be nice to take, of course, I think we have questions. And part of what A.T.Socio Consulting is doing is to encourage and empower other Africans. So we have, as one of our staff here, a DRC citizen. She's an intern of one of the colleges. Her name is Liz. So Liz, I will give it to you to ask the questions if there are any questions for us.
Thank you so much, Judge. May I stand on the existing protocols? My name is Liz Bikaba, and I'm from the Democratic Republic of Congo. I'm a legal studies student with a political science minor at Canon University in Pennsylvania. And today I will be reading all the questions. The first question we have is, where electoral rules and guidelines are disregarded or flawed, don't you think this might affect investors' confidence in our legal system? Thank you.
Which of the presenters would like to take that question, please?
Yes, I believe that where you flout these electoral rules, the perception of anybody would be that whatever the outcomes, whatever declarations, if not overturned, then for as long as they are convinced that those rules were flouted, they will not invest. And they should not invest because naturally it threatens national development, it threatens security, and of course, the economy will be affected. So why would you invest if you're not sure of what is the outcome and the reaction of the country would be? So my answer to you is, yes, it will affect and prevent anybody from investing once it is established that there's been a flouting of the rules, of the electoral rules of the country, as is presently being alleged. And besides, there are international standards that are expected. And it's those, once that is not met, the people become circumspect. Thank you.
Liz, we're waiting for you.
Thank you. The second question starts with greetings. Good afternoon, the moderator. After the last elections, the refrain, if you are aggrieved, go to court, is continually heard. And with the recent judicial pronouncement, the public is left without hope. My question is, what do we do about the fast eroding confidence in the judiciary? If you are aggrieved, go to court, is continually heard. And with the recent judicial pronouncement, the public is left without hope. My question is, what do we do about the fast eroding confidence in the judiciary?
Okay. Judicial officers, first and foremost, are members of the public. They read newspapers, they listen to conversations in buses, in public places. But when it comes to proof before the court, these are not the things they use. Proof before the court is most crucial, and it must be hard evidence rendered before the court. So I don't think it's fair to say that rules are just being breached by not making petitions succeed or thereabout. But the point is that there must be proof based on hard facts before the court can decide. We don't use what we hear outside to reach conclusions in our cases and decisions.
So, my lord, is it?
So I think that here, yes.
I beg your pardon, my lord. So, is it that because of the fact that the courts are dealing with more of proof and evidence, that the public confidence of the court would be questioned, because the question ended up asking about how to restore public confidence in the court as a result of electoral cases.
No, the public confidence arose from probably because they think what they hear on the streets are the basic facts, and which is not always the case. You see, I pity the situation of the court in this regard, because what you hear on the street is not what is proved in the court. And then the court must stand this ground. You cannot just base your decision on what other people have heard or what other people have said on the street. So it is unfair. Like somebody has mentioned, we need a lot of education on these little issues for the public to know that the courts are deciding based purely on their conviction as to what the law says, not on any other extraneous matter.
Thank you, sir. Next question, please.
Thank you. Thank you so much. The next question is, my Lord Justice Ogebe, please explain your challenges in the Ladoja and Obi cases. What will be your words of wisdom to the CGN and this team? Thank you.
Right. Thank you very much for that question. My advice to the judges is the importance of interpreting the Constitution and the law as it is without looking at anybody's eyes or face to do justice and pure justice. In the case of Ladoja, some members of the State Assembly in Oyo State had disagreement. And so some of them led the House of Assembly, went into a hotel room. They didn't have the numbers to impeach, and said they had impeached the governor. The speaker was not part of them. The deputy speaker was not part of them. They then suddenly chose somebody as the speaker to remove by the court. So we looked at the Constitution very carefully and said, well, those people, rascals who went into hotel room to impeach the governor, cannot constitute the State Assembly. And so we're able to wriggle out of it and restored the governor. And that's exactly what happened in the Ladoja case. And it was followed by Anambra State that hurriedly went and removed the governor of Anambra, Obi. Just shortly, just before we gave our own judgment, they quickly went and they were following what was happening. They quickly went and removed him. And again, it came before us in the Court of Appeal, Enugu, and we restored him. So the administration there was trying to make light the issue of removal of governor. And we said, no, if governor can be removed at the whim of any president, then there'll be no stability in the system at all. So I advise all judges and lawyers to be very careful to make sure that the law, the Constitution is not breached by politicians who are all out to find loopholes in which to breach the Constitution.
Thank you.
Thank you so much, my Lord. The last question we have is, Nigerian courts are fond of issuing judgments on elections matters based on technicalities of law rather than the overwhelming wishes of voters. A case in point is that of the current Senate President, Ahmad Lawan, who did not even participate in a primary election, yet the Supreme Court ruled that the procedure adopted by the winner of that primary election in filing his petition was improper, and decided to gift the position to Lawan, who didn't even aspire for the position, nor did he purchase the intention form of his party for the position. How can this impunity by Nigerian courts be checked? Thank you.
It's a tough question.
Yes.
Anyone wants to take on this one? I was hoping that Malam Ali was here. That would have been a question for him, but. Mr. Lawal, do you want to, you've already said somewhat, you said something along these lines in your recommendations. I don't know if you would want to address it for the specific person who has asked the question.
Okay, first and foremost, this emanates from one major problem. INEC grants supremacy to parties on how they arrive with their candidates in the primaries. The power is not vested in INEC, which is independent and non-partisan. It's vested in the political party. So regardless of how the outcomes or the laws look, whoever the political party wants to emerge in the primaries is who will emerge. They have their ways around it. They have their machinations around it. Of course, Ahmed Lawan bought an intention form for presidency, but underhandedly, a form was also purchased for Senate. That was an earlier infringement I made a comment about while talking. Mm-hmm. And that is not right, because you can't, according to the Electoral Act 2022, you can, in one election cycle, you can't bid for 2 offices within one set. But he did that, and this is Senate President, who is the custodian of the laws of Nigeria in the National Assembly. How can we fix this? I think Nigeria is not yet ready. I don't believe in us borrowing laws that are already practiced in other countries that have a stable democracy. We have to understand the growth and the youthfulness and the uncultured behavior of our politics, and decide to say, okay, when it regards your primaries, this is how it will go. If it goes any other way, INEC has the right to interfere. But as of now, the issue is the supremacy of parties in picking their candidates. Thank you.
Thank you so much.
Can I come in?
Yes, sir, please.
Yes. I think that is why in my paper, I try to suggest that pre-election matters of that nature should not go beyond the High Court, if at all. For it to go up to the Supreme Court and that kind of thing. The High Court rejected the position of Lawal. The Court of Appeal also threw out his appeal, and he got to the Supreme Court, and then we had that strange ruling. Well, frankly, I've been a justice of the Supreme Court. I disagree entirely with that ruling. And I've had occasion to discuss with some of the justices of the Supreme Court who don't agree with that either. That is why I say that such matters should be dealt with very carefully. These people should not have been given any opportunity. The Supreme Court is a court of, is a final court, and they should be careful not to give any ruling. In fact, they should be careful that even if it means applying their prerogative at the highest court to overrule some of these technicalities, like say, oh, the originator of the service of the suit did not file by originating someone, so this and that. These are technicalities. There was a case in Nigeria where a High Court judge was sentenced to imprisonment and fine for an offense. And eventually the matter, he appealed, the matter went to the Supreme Court. And the Attorney General of the state was objecting on technical grounds that, look, the grounds were defective and all that. The Chief Justice said, look, whether the man came on his head or out, that the matter is before us, and we're going to decide it right now. And they said, look, a High Court judge who is alleged to have not to have a gun license, in case up to that he didn't have a license, he shot somebody and all that. See, at Attorney General, can't you go and get the license for the judge? That's the kind of thing you're bringing here. There and then they charged and acquitted the judge. So the Supreme Court has right, even when there's a defective process, they look at the substance of the case and say, look, we're going to do justice in this case. That would have solved the problem. And until adjourning judges that they should be careful in election matters, not to do anything that will make the court infamous. But the majority of judges are very careful. They are good. They are not corrupt, as is being alleged. I remember that I was accused of being bribed by billions of naira in the Yaradua case. And I was compelled to go to court to sue for libel. And I was awarded 25 million against the newspaper. Because I didn't take a kobo from anybody. The same thing my learned brother, Justice Socio-Judicial, blessed memory. He's a Christian, he didn't take a break, but they went and publicized in Sahara and all sorts of things that we took bread. No, we didn't do anything like that. But that is a risk that we have as judges, that we should do our job with a clear conscience and with the fear of God for the benefit of the society.
Thank you, my Lord. My Lord, I'd like to take you a little back on what you just said, because the dead cannot defend themselves, to the blessed memory of my late irrepressible father. When Sahara reporters had disclosed that you and the late Nikitobi took a bribe, how did it make you feel, sir?
Well, I felt that when the professional has that, there are so many people who don't know anything about justice or anything, but they just open their mouth wide. So when they said that, I felt sad, but I said because it's based on ignorance, and that's important. It's important that the public should be educated on how judges operate. For instance, the Yaradua case, it was a notorious fact that certain things went wrong. Yaradua himself, as president, agreed that there was some flaw in the process that brought him in. But to prove it in court, it's a different matter. People did not produce enough evidence for us to overturn that election. But we didn't take bribe, nothing. We're based purely on the law.
That's what Lord Justice Onum was saying about evidence and proof before court and the issues of public confidence. And I think the same thing that Mr. Lawal, you say you're not a lawyer, but you have hung around lawyers enough. I think you are one. We should give you an honorary degree in law. He has specific, Mr. Lawal has said the judiciary needs better communication, but what unfortunately he does not know, and I think I would supply him with information because I know he likes to read, is judicial ethics. The code of conduct of a judicial officer is tying the hands of judicial officers, and they have sworn to an oath that they would abide by that ethic. So judges cannot talk for themselves. So part of what, if you go on our website, you will see where I had a recording of the dilemma that judges have to face. And I think it was Leonard Senior Advocate Rabana who said that judges are human beings. You know, I think everybody's talk has been connected in such a way that our judges is in a dilemma. We are in a situation where judges the whole world is looking at judges, you know, and thinking, what are you going to do? Nigerian judges, what are you going to do? As part of the comments, actually, responses, like that I said earlier, somebody said this, how this trend should be stopped, especially as it is eroding the confidence of the people in the judiciary. A case in point is the CJN's movement. A case in point is the CJN's movement, that is Chief Justice of Nigeria, for those who don't know, is being, because a lot of people also are attending from other countries who are lay and not lawyers but just public people from the society. A case in point, I'll take that again, is the Chief Justice of Nigeria's movement is being watched with suspicion, as he's seen as the one to decide the presidential election petition. For whoever made this comment, and that is not entirely true, and that is part of the education that the judiciary should be finding out. The Chief Justice does not take a decision alone. We're in a democracy. The Chief Justice has other panels that would decide, and if they don't have a quorum, I'm sure Justice Ogebe would tell us that. They don't have, not a quorum, I beg your pardon. If they don't have, Milord, what do you call it in your inner caucus? If they don't have, if the panel does not decide on the particular point, then it doesn't become a principle, it becomes an obiter. So person goes on to say the one to announce our next president. Any infractions on his part, talking about the Chief Justice now, will bring judiciary into great disrepute. Whoever wrote this comment, question, you are right. Justice Ogebe, please, you want to say something in response to that, my lord?
Yes. So you know that for the presidential, at the Court of Appeal level, there must be 5 judges or justices of the Court of Appeal, and not a single one of them can overrule the other. Everybody has his own opinion. Exactly. They can disagree, but the majority judgment will prevail. Like my own, when I did the Yaradua, 5 of us all agreed, and there was no dissenting opinion at all. But when it went to the Supreme Court, there was some dissenting opinion. I think it was 4-3, but the majority prevailed. So there's no single judge that has the power to overrule. Even if you are the Chief Justice, you can be sidelined if your colleagues don't agree with you. Judges have independent minds, and there's no way that you can force a judge to agree with you.
Thank you, sir. Very important. Judges have an independent mind. So those of us that want to crucify the Chief Justice, please note that he is part of the panel, not entirely up to him to make the decision. So when, like SAN Ali said, let's stop making this construction site and marketplace noise and rumors, and let's listen to what is. And unfortunately, we don't have people talking on behalf of the court, so we'll take that Ambassador Bande's recommendation that we should get people knowledgeable in judicial issues and modus operandi to be connected with the press, so that we can, the media, so that we can get information out there. Do we have the last question, please?
Yes, Judge, we have the last question. How the courts, rather than the people's votes, is gradually deciding our elected leaders in Nigeria, and how these trends can be reversed? That's the question. Thank you.
Thank you. Anybody wants to take that? How can the trends be reversed that people's votes are now determined by the courts? Is anybody going to respond to that or answer? It seems like a comment, but I think it's something worth talking about.
Well, I think it's a principal constitutional situation. You have the legislature, you have the executive. These are all politicians. And then you have the judiciary. So if the politicians have disagreement with one another, there's no way they can resolve the disputes themselves. So both sides, all of them are interested. That is why they created the judiciary, which is supposed to be impartial, to be fearless, and to do the right thing. So as I said earlier on, it's an enormous responsibility for the judges to decide on these election matters, but somebody has got to do it. And so that is why I joined that judges who are involved in election matters must be courageous, must be fearless, must be God-fearing, and do what is right. Should avoid bribery or partisanship and do what is right. So I can't see that ever changing, because you leave it back, people are fighting each other over who should be president and that, and then you leave it back to the politicians, or what do? There must be somebody must decide the case, and that onerous duty has been placed upon the judiciary in the Constitution. I cannot foresee any situation whereby we leave it to a free-for-all fight. The judiciary is supposed to be an umpire in deciding such matters.
Thank you, my lord. Thank you, my lord. And if I may say something to that person who asked the question, unfortunately, that trend cannot go away. We are coming to a place where the courts will definitely have to be making decisions for us eventually, except human beings stop to fight and there are no conflicts. Like Leonard S.A. and Ali said that litigation, can stop eventually, but I don't see how that is possible with the kind of economic situation where lawyers would actually need litigations to feed their families, right? So if ultimately there are conflicts, they will always end up in a democracy, they would always end up in court. So thank you all for your comments, your answers, your questions, your presentations. I just wrote this out in the course of my research pre and post the elections. And I say, if they could mean as many out there, he who wears who the cap fits can wear it, got away with bribery at the polling units, if they falsified the records in Form ECHA, if they got away with fake results collations at the ward collection centers, if the supervising lecturers from various universities that collate the votes compromised each party's votes, if the security registration centers, local government collation centers tweak the result sheets, if passwords were compromised and the people's views are stifled, if they succeeded in bribing their way through the state collection centers, will they repeat same with the judiciary? A2, judges, the world awaits your verdict, as Leonard Rabana said, SAN. The world is looking at you. Everybody is paying attention to the Nigerian judiciary right now because of the strategic place that our country plays in global economy and global democracy. The ball is in your court, judges. Kick it to the side of constitutionalism and let the rule of law and good governance score the goal. The late Nikki Toby of blessed memory says, let no judge flirt with politicians in the performance of their constitutional adjudicatory functions. When I say this, I must also say that I have nothing against politicians. They are our brothers and sisters in our homes. One can hardly find any Nigerian community or family without them. There cannot be democracy without them, and we need democracy, not despotism, oligarchy, and totalitarianism. They are jolly good fellows. He goes on to say, the only point I am making is that their professional tools are different from ours, and the Nigerian judge should know this before he finds himself or falls into a mirage where he cannot retrace his steps to administer justice. That type of misfortune can fall on him if the National Judicial Council gets annoyed of his conduct. Ours are not theirs, theirs are not ours. I will not say more. I will not say less too. So be it. Thank you so much. We are right on time, and this is the end, 11:30 sharp. Thank you all for being with us. And we can go if we want to, but we have post webinar presentations or whatever I would call it to make. The books of our presenters, some of them in the past, and those that presented today are here. Justice Ogebe's book, Under the Shadow of the Almighty, and Mr. Kunle Lawal, the candidate, and then we have Justice Onum, The Pathway Through Effective Litigation, the Area of Customary Courts in Nigeria. At the chat tools, we have where you can get their books. Those that you cannot get on Amazon, you can call the respective numbers that we have provided for you. So thank you. And then Malam Nusif Ali, Anatomy of Corruption in Nigeria. So these are all the books and of all our previous presenters as well. Thank you so much. The next webinar will be Women Judges' Impact in Society and Democratic Development. That will take place sometime in July. I'm hoping we've not gotten our guest keynote speaker to give us a specific date. She's a very busy woman. And As soon as we get that, we would put it on the sides. Thank you, thank you, thank you.